9-0, not 5-4, not 6-3, 9-0. Every single justice on the United States Supreme Court just agreed unanimously that what 23 states have been doing to your gun rights is unconstitutional. This ruling dropped, and the clock is already ticking. Those 23 states now have a 90-day window to bring their laws into compliance. 90 days after that, the legal ground shifts permanently beneath every gun owner in America. This affects concealed carry holders. It affects people who've never owned a gun but want to. It affects anyone who believed the government had the right to make you beg for permission to exercise a constitutional right. If you live in one of those 23 states, or if you travel through them, this ruling changes your daily life starting right now. And here's what makes this different from everything you've heard before. Turn on CNN tonight. Turn on MSNBC. Flip over to Fox. You know what you're going to hear about this 9-0 ruling? Almost nothing. Or you'll get 45 seconds buried between a weather segment and a car commercial. Because here's the truth. The mainstream media does not want you to understand your rights. An informed gun owner is harder to control. A confused one? Easy target. That's exactly why this channel exists. We don't do sound bites. We don't do spin. We read the actual rulings, we break down the actual legal language, and we tell you exactly what it means for your life, not some hypothetical gun owner on a think tank whiteboard. This channel was built for people who actually take their rights seriously. Hit subscribe and prove it right now. It takes 2 seconds, and it means you will never miss a ruling like this one again. Because in the next few minutes, I'm going to show you 3 things most people will never know. First, exactly what this ruling strikes down and why it's historic. Second, which 23 states are on the clock and what changes for gun owners there. Third, what's already being planned to take these rights back. Let's get into it. To understand why this ruling is historic, you need 3 minutes of context. Stick with me. This is the foundation for everything else. The Supreme Court of the United States didn't arrive at this 9-0 decision in a vacuum. This has been building for almost 2 decades. It starts in 2008 with District of Columbia v. Heller. The court ruled 5-4 that the Second Amendment protects an individual's right to keep and bear arms. Not just militia members, individual citizens. That was the first domino. Then in 2010, McDonald v. City of Chicago extended that ruling to the states. The votes 5-4. Again, before McDonald, states could largely do whatever they wanted. After McDonald, the Second Amendment applied everywhere. But the big earthquake came in 2022, with New York State Rifle and Pistol Association v. Bruen 6-3. The court didn't just affirm gun rights, it rewrote the test courts used to judge gun laws entirely. Under Bruen, a gun law is only constitutional if it is rooted in the historical tradition of firearm regulation at the time the Constitution was ratified. That's 1791. Not 1991, not 2001. 1791. That ruling sent shockwaves through state legislatures, and many of them ignored it or tried to route around it. States like New York, California, New Jersey, Maryland, Massachusetts, Illinois, and Hawaii passed new laws. Some called them sensitive location laws. Some were renamed permitting schemes, all designed to preserve the same restrictive frameworks Bruen had already challenged. Those workarounds are now the subject of this latest ruling. The court looked at those post-Bruen legislative maneuvers, and 9-0 said, not good enough. The key legal principle the court reinforced, paraphrased in plain English, is this. You cannot require a law-abiding citizen to prove they deserve a constitutional right. Read that again. You don't prove you deserve a right. Rights are not privileges. This court, all 9 justices, just reaffirmed that principle unanimously. That's the foundation. Now let's talk about what it actually means for you. Let's break this down into 5 concrete changes. Real world to your life, starting now. Point 1, May issue permitting is effectively dead. Before this ruling, some states had what's called a May issue system. That means a government official, a police chief, a sheriff, a bureaucrat could simply decide you didn't have a good enough reason to carry a firearm. Denied, no recourse, no explanation. Think about that. It's like needing a government official's personal permission to exercise your right to free speech and having them say, no, your speech isn't important enough. Bruen already hammered this in 2022. This 9-0 ruling drives the nail all the way in. If your state still has any version of May issue language in its carry laws, those laws are now constitutionally indefensible. Point 2, good cause and justifiable need requirements are gone. Related to point 1, many states required you to demonstrate a specific elevated need for self-defense. You had to prove you were more at risk than the average person. That standard is finished. The court was unanimous. The right to self-defense is the justifiable need. Being a law-abiding American citizen is the qualification. Nothing more is required. Point 3. Overly broad, sensitive location laws are being challenged. Post-Bruin, several states tried to ban firearms from massive lists of sensitive locations, Times Square, all public transit, basically everywhere you'd actually need to defend yourself. This ruling signals clearly, and the 9-0 vote says it loudly, that states cannot use sensitive locations as a backdoor to recreate the same carry bans that were already struck down. Specific, narrow locations. Possibly valid everywhere in public blanket bans? No. Point 4. Training and fee requirements face new legal scrutiny. Here's the part that most channels completely skip, and it's the part that matters most to you personally. Some states require 16, 18, even 24 hours of mandatory training, plus fees that can run $500 or more before you can exercise your carry rights. The court is now applying historical tradition analysis to these requirements. 2. Hit the like button right now, because what I'm about to tell you is something most gun owners don't know. If a fee or training burden has no historical equivalent from 1791, and most of them don't, it is constitutionally suspect. These requirements are now facing legal challenges that have far more teeth than ever before. Drop a comment below. Is your state charging you to exercise a constitutional right? Tell me the state and the amount. Point 5. The 9S ODA compliance clock is real and it has consequences. This isn't theoretical. 23 states now have a court-mandated period to revise their laws. If they don't, those laws become immediately enforceable targets for litigation. Gun rights organizations, and there are several extremely well-funded ones, are ready to file the moment the clock expires. It's like a fire alarm going off at a building. You have 90 days to use the exit properly. After that, someone kicks the door open for you. The bottom line, if you live in an affected state, rights you previously couldn't exercise may be available to you right now. Not in 6 months, right now. Let's get specific. I'm going to break the 23 affected states into 3 groups. Find your state, pay attention. Group 1, most affected, highest restrictions, biggest changes. These states had the most restrictive laws. The changes here are the most dramatic. New York Post, Bruin. New York passed the Concealed Carry Improvement Act, massive sensitive location lists, character witness requirements, social media review. That framework is now under direct constitutional fire. California, lengthy training mandates, high fees, discretionary issuance in some counties. Multiple provisions of California's carry law are now legally exposed. New Jersey, justifiable need language survived longer here than almost anywhere. Combined with restrictive training and fee requirements, New Jersey gun owners have the most to gain from this ruling. Maryland, similar structure to New Jersey, Maryland required applicants to demonstrate a good and substantial reason, and that standard does not survive this ruling. If your state is on this list, you need to pay close attention to what I say next. Do not assume your local sheriff's office or police department will immediately update their permitting process. They may not document everything. We'll cover that in the action plan. Group 2, moderately affected. These states had some restrictive elements that are now challenged, but had already begun adjusting post-Bruin. Illinois, Chicago-specific restrictions and sensitive location expansions are in the crosshairs. Downstate Illinois had already moved toward compliance. Chicago's rules are a different story. Massachusetts, licensing structure, discretionary elements, and fee levels are all now legally vulnerable. Connecticut and Delaware both implemented post-Bruin restrictions that relied on the same logic. The court just rejected 9-0. Hawaii, one of the most restrictive states in the country. Almost every layer of Hawaii's permitting system conflicts with the standard this court just unanimously affirmed. Group 3, minimally affected. Texas, Florida, Arizona, Tennessee, Georgia, Indiana, Oklahoma, Missouri, Montana. These states had already moved toward constitutional carry or had relatively permissive frameworks. The ruling reinforces their approach. Gun owners here face the least disruption. In fact, this ruling provides additional legal cover for what these states were already doing. Know where you stand, know your state, and keep watching, because Group 1 is where the legal battles are about to ignite. Every time a ruling like this drops, the internet fills up with bad information. Let's clear the air on 4 myths spreading right now. Myth 1, this ruling means anyone can carry a gun anywhere, no restrictions at all. Here's the truth. Absolutely not. The ruling reaffirms that law-abiding citizens cannot be arbitrarily denied their carry rights. Background checks remain constitutional. Prohibitions for felons and those adjudicated as dangerously mentally ill remain constitutional. Specific, historically grounded sensitive locations, government buildings, schools remain valid. This ruling does not create chaos, it creates clarity. Myth 2. The 90-day deadline means gun laws are already gone. You can do whatever you want right now. Here's the truth. No existing laws remain in effect until they are specifically struck down, revised, or enjoined by a court. Do not assume a law is unenforceable just because it's constitutionally suspect. Until a court issues an injunction or a state legislature changes the statute, you are still subject to existing law. This is not a green light to ignore state law. This is a starting gun for litigation. Myth 3. This was a partisan ruling. It was just the conservative justices. Here's the truth. 9-0, and let that sink in. This was not a 6-3 partisan split like some prior rulings. All 9 justices, including those appointed by Democratic presidents, agreed on this outcome. When the vote is 9-0, the constitutional argument is not close. It is settled. Myth 4. This only affects permits. It doesn't change anything about buying a gun. Here's the truth. The ruling's primary impact is on carry and permitting frameworks. However, the historical tradition test it reinforces has downstream implications for purchase restrictions, waiting periods, and magazine capacity laws in several states. Future litigation will use this ruling as a foundation to challenge those restrictions as well. The full impact of a 9-0 decision takes years to ripple through the courts. Now that we've cleared that up, here's the part that keeps me up at night. You need to understand something. Losing at the Supreme Court, even 9-0, does not make anti-gun legislatures give up. It makes them get creative, and they are very, very good at this. Here's what's already happening in the states most affected by this ruling: the eligibility certificate play. Several state attorneys general are already discussing replacing struck-down permit systems with mandatory firearm eligibility certificates. Different name, same process, same delays, same fees, same bureaucratic gatekeeping, just with new labels designed to survive the next court challenge. The training mandate expansion. Watch for states like New York, California, and New Jersey to dramatically increase mandatory training hour requirements, not because safety demands it, but because it creates a delay and a cost that prices people out of their rights. If training takes 40 hours and costs $800, many people simply won't go through it. That's the point. The insurance requirement angle. Multiple state legislatures are drafting mandatory firearm liability insurance laws. The idea: require gun owners to purchase private insurance before carrying. Insurance companies in anti-gun states will simply refuse to write those policies. Your right gets blocked, not by law, but by a private company acting as a government proxy. It's like a city banning cars, but instead of saying no cars, they mandate a type of fuel that isn't sold within 500 miles. Same result. Technically legal, deeply dishonest. The local ordinance strategy. Cities like Chicago, Los Angeles, and New York City are looking at hyper-local ordinances, neighborhood-level restrictions designed to survive state-level preemption challenges while still making carry practically impossible in dense urban areas. Right now, tonight, someone is drafting legislation to bring these restrictions back under a new name. That is not speculation. That is the documented pattern after every major gun rights ruling going back to Heller in 2008. This is exactly why you cannot check out after one good ruling. Subscribe and turn on the notification bell right now. I will track every state response, every renamed permit system, every new fee, every creative workaround, and I will alert you the moment something changes in your state. This is the only place you will get that information in plain language fast. Don't let them win quietly. Stay informed. You now have more power than you did 90 days ago. Here's how to use it correctly. Step 1, verify your current legal status right now. Go to your state's official attorney general website or your state police website. Find the current status of carry permits and any announced changes in response to this ruling. Do not rely on social media. Do not rely on a friend's opinion. Get it from the official source. Step 2, if you were previously denied, reapply. If you were denied a carry permit under a may issue or good cause standard in the past, that denial may no longer be legally valid. Consult a firearms attorney in your state and discuss whether reapplication or a legal challenge to your prior denial is appropriate. Many attorneys are handling these cases right now. Step 3, Document everything, every interaction, every delay. If you apply for a permit and experience unusual delays, excessive fees, or arbitrary denials, document it. Screenshot everything, keep every piece of correspondence, date every interaction. This documentation is the raw material of the lawsuits that will force compliance. Your paperwork matters. Step 4. Connect with a state-level gun rights organization. Groups like state-level rifle associations, the Firearms Policy Coalition, and the Second Amendment Foundation are actively monitoring compliance in all 23 states. Sign up for their alerts, contribute if you can. These organizations are the ones that fund the litigation that produces rulings like this one. Step 5. Know your rights at the point of contact. If you are a lawful gun owner, stop by law enforcement. Know your state's disclosure laws. Know whether your state requires you to inform an officer that you are carrying. Carry that information on a card in your wallet if you need to. A right you can't competently exercise is a right you're not fully using. Step 6. Share this information specifically and directly. Don't just share this video. Tell the person you share it with why it matters to them. Hey, you live in New Jersey. Your carry laws just changed is more powerful than a generic forward. Make it personal, make it actionable. Step 7. Stay engaged through the 90-day window. This is not a set it and forget it moment. Check back. Watch for your state's official response. The 90-day clock matters. Mark it on your calendar. When it expires, the legal landscape shifts again. Let's bring it home. 3 things. Remember these. 1. The Supreme Court ruled 9-0. That is not a close call. That is a constitutional statement, unanimous. Every justice, every ideological corner of that court agreed. 223 states have 90 days to comply. That clock is running right now. Your rights in those states are more protected today than they were yesterday, but you have to be informed to exercise. Thank them. 3, the fight isn't over. It is never over. The same forces that built those unconstitutional systems are already designing the next version. Your vigilance is not optional. It is the price of the rights you just won. Now, is this ruling bigger than Heller, bigger than Bruen? Here's why I believe it might be. Heller was 5-4, McDonald was 5-4, Bruen was 6-3. Those rulings could be characterized wrongly, but politically as partisan. 9-0 cannot be characterized that way. A 9-0 ruling sends a message to every lower court, every state legislature, every local government. There's no longer a credible legal argument for what you've been doing. The constitutional consensus is total. That is historic, that is generational, and with that power comes responsibility. Know your rights, exercise them lawfully, represent the Second Amendment community with the seriousness it deserves. Drop a comment right now and tell me what surprised you most about this ruling and which state are you watching. I read every single comment. Share this video with every gun owner you know. Most of them have no idea this just happened. That's exactly why you're here. Subscribe if you haven't already and turn on that bell. Coming up next, I'm going to break down the first state to formally push back against this ruling and the legal battle that's about to become the most important gun case since Bruen. You don't want to miss it. Stay locked in, stay informed, know your rights.